Good day, Mr. Mooki. Did I pronounce your name correctly?
Good afternoon, Deputy Chief Justice. It's Mooki.
Oh my goodness, Mooki.
Mooki.
Please forgive me. All right. I see that you're still being handed documents. Have you settled in?
Yes, I believe I'm settled.
All right. How are you?
I'm well, thank you very much.
All right. You obtained a Bachelor of Science in Immunology and Microbiology, then went on to do a Master of Science in Physiology. But here you are today. How did you change course? What happened?
Right, well, perhaps I've come full circle in that on finishing matric, I got admitted to Natal Medical School and to the University of Botswana. Parents didn't have funds for me to go to Natal, so I ended up registering for the B.Juris degree at UNIBA. So perhaps it's in that sense that I've come full circle back to the law.
Right. Well, you started out as an attorney.
Yes. I practiced as an attorney for 2 years, and thereafter I was a senior legal advisor at one of the banks, but that was for a very short period.
Yeah. What changed your mind so quickly?
I was always minded to go to the bar at some point, and it was made known when I was working at the bank that pupillage was going to change from 6 months to a year, and I took the view at the time that if I didn't go to the bar now, I would never go to the bar. So that is the reason why I left my employment with the bank and came to the bar through pupillage. All
right. And you have been at the Joburg Bar since December 2003?
Yes.
Okay. You have acted as a judge since 2012, I see.
Yes, I started my sessions at the Labour Court, and I believe that cumulatively I would have at least 3 full terms in total at the Labour Court, and then I have had further sessions in the High Court.
You had a longish stint at the Labour Court, 3 years, during which you managed to produce 20 judgments?
Yes, I did deliver a number of judgments, some of which are reported.
Yes. And how long have you acted at the High Court?
2 full terms, and I believe, I couldn't quite get my numbers right, I believe perhaps 5 additional weeks.
Yeah. Well, we do have a spreadsheet from JP Mlambo, so we can check on that. Did you manage to produce written judgments in the High Court?
Yes, I have, and they are included in my pack.
Yes. Any of them reported?
Not in the traditional law reports, but I do have a number of judgments from the Labour Court which are reported in the traditional law reports.
When was your last acting stint in the High Court?
The very past term. I had a full term in Pretoria.
Do you have any leftover, any reserved judgments?
I do. I have an outstanding judgment from the Third Court. It's a rather involved matter which is taxing, but I do believe that it's within the 3-month period. So,
yeah. You list a number of fields of practice that you've had the opportunity to dabble in. It's a wide range: public law, labor law, medical negligence, commercial law, competition law. But you state that you have not done any criminal work as a lawyer, well, as a practitioner?
Yes, I haven't practiced in a criminal court at all. In my recent stint, I sat in a number of appeals, criminal appeals. But as far as practice is concerned, I have not practiced in the criminal courts.
How did you fare in the criminal work at the High Court now?
Well, in an appeal, really, it's a matter of law. So one has to read up on the law. And I did not find it particularly taxing.
But you've not had an opportunity to run a criminal trial?
No.
Okay. You have done a few other things. You chaired the Water Tribunal at some stage.
Yes, well, I sent through a correction. I was a member of the
Oh,
panel.
sorry, my mistake. Yeah, you were a member.
Yes.
When was that?
2000 and, I believe 2004 to about 2007. So it was more than 3 years. And as I recall, that could have been the first water tribunal that was constituted given the new act.
Did you write any judgments there?
Yes, I wrote a number of rulings, and some of which are also in the pack.
Yeah. You were awarded Silk in 2018.
Yes.
Right. All right. I will leave it here, Mr. Mooki, and hand over to the other commissioners to put questions to you.
Right.
Judge President Mlambo.
Thank you, DCJ. Good afternoon, Advocate Mooki.
Good afternoon, Judge President.
You've never corrected me pronouncing your surname incorrectly.
Perhaps my ears deceived me. I'm known to be particular with how my name is said. So if I thought that it was not said properly, I'm certain I would have let you know.
I think I start where I start with other candidates to thank you for having come in the division to aid and assist us. And you've seen that we do need an extra pair of hands. Am I correct?
That is so.
Thank you. Just quickly through your acting stints, according to the information I've gathered, you've had a total of 29 weeks in the labor court, which is the 3 terms you mentioned. And the bulk of that has been in the urgent court. That's 7 full weeks, and in the opposed motions court, which is 9 weeks. Am I correct?
Yes.
Thank you. You've done work here and there in the other areas like trials, and you've had leave to appeal applications. But in the High Court, I see you've done 4 weeks in the opposed motion court, and you've done 2 weeks in the urgent court as well as a special motion. That's the one you mentioned.
Yes.
That you say you found taxing.
Yes.
Now, you've written a number of judgments as well, and have you written a judgment that was more than 6 months old?
Certainly not in the High Court.
Yes.
It's very possible that there could be one such judgment during my session in the Labour Court.
I see, yeah. But in your varied experience, I mean, you're Silk since 2018. You've appeared in the High Court, obviously. You appeared in the SCA in Concord?
I have appeared. I appeared in the Supreme Court of Appeal once. I appeared twice in the Constitutional Court. And if I may add, as far as the Constitutional Court appearance is concerned, I had been at the bar for 2 years before my first appearance.
Yes.
At the Constitutional Court, but those briefs are far and few in between.
Yes, yes. And I've looked at your list of judgments. Despite, I think it's what, 29 weeks plus 21 weeks. That's quite some time, and it's quite a number of judgments that you've penned in both courts.
Yes.
And you say 3 of them are reported in is that the Industrial Law Journal in the Labour Codes?
I could be more than 3, but yes, I think a decent number from my session in the Labour Court are reported in the traditional law report.
Yeah. Have you found the work manageable in the High Court? Because that's where you are focused. I mean, traditionally, you get about 12 to 14 files for the week in the opposed motion. And those are cases that have counsel on both sides, sometimes more than that. How have you found that work?
I found the work manageable, and I must say that my sessions at the Labour Court stood me in good stead. The court in Braamfontein is very busy, and so it wasn't that a surprise for me as such when I came to the High Court and got allocated matters in opposed court. But one has to say that it is a taxing court.
And the urgent court in the High Court? I mean, how did you find that? The tempo?
It helps that one was at the bar.
Yes.
So you have a sense of what needs to be dealt with.
Yeah.
And one would have developed a facility for identifying issues that require resolution.
Yes.
And I think that ability, despite it being the urgent court, it doesn't make the court forbidding.
Yeah, okay. And you feel, especially, as you say, the stints in the Labour Court stood you in good stead when you came to the High Court, and you feel you can handle the work on an ongoing basis, and that's why you're here.
I believe I can.
Thank you. Thank you very much, DCJ. I'm happy.
Oh, Premier, do you have questions for the candidate?
Yes, if you don't mind, DCJ.
Go ahead.
Chairman. Good day, I advocate Mooki.
Good afternoon, Premier.
And I might be wrong, advocate, according to your CV, I'm not seeing any element of community upliftment, either in the circle of youth development, church, sport, or any sector of our society. Does this mean that you might be dealing with our communities and understanding what is happening in our communities?
Premier, I didn't quite, the line is not, it's not ideal, but I seem to understand you to be asking about my involvement in community life. I believe that
Yes.
I believe that I have always been involved in community life. It might not be through, for lack of a better description, the traditional sense of what that would entail. I consider that I do have a care for public life. There are a number of organizations which I've listed in my pack, which I've been involved in, and I do believe that those also are an expression of a person who has an interest in public life.
Thanks, DCJ. I'm fine, thank you.
Thank you, Premier. Minister? Commissioner Mulemela?
Thank you, DCJ. Good afternoon, Mr. Mooki.
Good afternoon, Madam President.
Yes, thank you. I listened to the exchange between you and the JP, and I'm encouraged by the fact that you have presided over matters in the Asian court. Did you, on any occasion, have to deal with an ex parte application?
Not as counsel, but
No, I mean,
as a judge.
as a judge, yes.
Yes,
Did you have to
yes.
consider it?
Yes, I had one such matter when I sat at the court in Johannesburg in the past year.
What kind of relief was sought?
The relief was to secure evidence, was to preserve evidence.
Yes. And what order did you grant?
Well, that is the order that I granted. Well, the substance of the order was that the applicant, with the protections that traditionally would be included, that the applicant was permitted to enter the premises of the particular respondent through the aid of the sheriff. This happened to be in an Anton pillar with the aid of a sheriff and a designated attorney, and they were authorized to secure the evidence. There were protections as to what could be done with the evidence and where it could be put.
Would you describe it as a run-of-the-mill order that is granted, or is it granted only in exceptional circumstances?
Well, it's not run-of-the-mill. I wouldn't quite say it's exceptional circumstances as such. It's a unique type of relief because it goes to preservation of evidence. But of course, it being ex parte, that is to say, without notice to a respondent, and what will be before the court will be what the applicant says. There are a number of important obligations as to disclosure by the applicant, and so the court has to be satisfied that, given the basic principle of a court having to make a decision with reference to what both parties have to say, in this instance, there will be only one party. So that when the court makes that order, the court will have to be satisfied that there is no abuse of the court process or an injustice. And when rendering the order, of course, it's not final, and the other party would have occasion in due course to have their say in court.
Thank you very much, Mr. Mooki. Thank you, DCJ.
Commissioner Marumachai?
Thank you very much, DCJ. Good morning, Mr. Mooki.
Good afternoon, Professor.
Oh, good afternoon. I beg your pardon. Should you be successful, and you are most likely also to be put into the urgent court, and of late we see a lot of applications being dismissed where judges are saying this is self-imposed agency, and it seems like while at times practitioners take chances, but sometimes you find that there are meritorious sort of applications which, even though they are meritorious, they may not be meeting the test for agency. I just want to get your sense as to what is the test for agency. What does one have to satisfy in order for you as a judge to grant an order on an urgent basis?
Sure. The law in this division certainly has come to be accepted to be as set out in the ISROC matter, and there the court will ask whether the applicant may not get recourse in due course. That, in substance, really would be the test as far as the aspect of agency is concerned.
That's where you are going to leave it.
I beg your pardon?
I'm saying that's where you are going to leave it. I was just thinking that perhaps maybe you'll take me through, is it rule 612?
Well, yes, of course, there are the other requirements. I thought you wanted to know on the agency aspect to what a court will have regard to.
Actually, that will be part of the inquiry. I just want to understand when I approach you and I come before you and I say that this matter is urgent, what
Yes.
do I need to prove for me to succeed? I mean, do I just have to show you that there will be or there will not be relief in due course? Is that the only thing that I need to deal with?
Well, no, of course, the other usual related part would be a party may seek, for example, an interdict, and then there you will ask whether the applicant is seeking final relief or if there's an interim relief. And if that be the case, depending on whether it's final or interim, one would apply the rules as to one or the other.
No, that's fine. Thank you very much, DCJ.
Follow up justice quickly on this. Just a follow up on this. I'm not too sure. Are you saying in an urgent application, the applicant must show that there will be no, he would not be afforded remedy in due course? Well, I don't get what.
Yes. Basically, because of the nature of the court process and because of the demands in the court, the sense of fairness to all litigants is that one must be in the queue. Yes. So when a litigant comes and says, my matter is urgent, that litigant has to justify to the court why the court must allow that litigant to go to the front of the queue in circumstances where there are other litigants whose matters have been pending for a very long time, but without being allocated a hearing. So it's a form of control that the court has.
All right. Just on this, and then if the court is of the view that the matter is not urgent, can it dismiss that application for lack of urgency?
No, the court can't. If it's not urgent, the court is not going to hear the matter. It can't hear the matter.
Commissioner King?
Thank you, DCJ. Good afternoon, Ms. Mooki.
Good afternoon, Commissioner.
I have given an opportunity to the other members of the bar, that is, to give the Commission some indication of the public spirited work they've done or service to the community and the bar itself as a way of indicating your involvement with community, because it may be a distinguishing feature between some of the applicants that are competing for only 4 vacancies. I see that you have served as a member of the professional subcommittee of the Johannesburg Bar, and you've also been an editor of a journal called Perspective at the Cape Town Law School. Perhaps you could give us some indication of the time commitment to the professional subcommittee and what your contribution was there, or whether there's any other significant contribution that we should know about.
Yes, Perspective was what we thought at the time was a radical publication in the law school, which was meant to be independent of the other publication, which was the one put up by the faculty. As far as the bar is concerned, I like to believe that I have been involved in the life of the bar since I joined the bar, not only as a member of the professional committee. I have always been involved in the training of pupils. I'm a lecturer in the bar's advocacy training program, which is an enterprise. Don't quite recall whether it's once or twice a year, but annually the bar has allocates time for trainers and judges to attend at the bar for the training of pupils. And I like to believe that outside of the bar as an institution as such, within my practice, that I have retained an interest in the life of baby juniors. They see me as a mentor. They often come to me as an ear, someone who, for one reason or another, they are comfortable coming to me for a hearing. So, in my way, I've always been involved in the life of the bar.
Commissioner Singh? Commissioner Singh?
Sorry, DCJ. Good afternoon, Advocate Mooki.
Good afternoon, Commissioner.
I was looking at your publications that you've listed here, and I was interested to see one is on forensic identification and criminal justice. Now, we know that justice is delayed due to paralyzing forensic cases, and then there's been a huge backlog in that particular department, which for some reason or other, in one quarter, the Minister of Police indicated to us that it had dramatically reduced from about 270,000 cases to 1,600. I don't know what magic wand they waved at that time to make that happen, but he told us that there were a number of additional people employed. What importance do you place on DNA and forensics in terms of the justice system?
Well, DNA would be one of the tools that will be available, should be available in the criminal justice system. The issue is how that is to be policed, given that the information that's detailed in the genes isn't only the DNA profile that is traditionally put up in the criminal system. There will be that profile in a database. There are issues about what is the integrity of the database, who has access to the database, what recourse can a person have when that material, for one reason or another, is spirited away from the database and find itself perhaps now being accessible to other parties who may want to do with that information at the time when, for example, when a buccal swab is taken, it would have been taken for a designated purpose in terms of the Criminal Procedure Act. So those are our concerns.
Yeah, the reason I'm raising this, DCJ, is, in a number of cases, particularly in GBV cases and other cases, you find that matters are delayed. And, I'm not talking about the Y chromosomes and the X chromosomes in the DA language that you know much better than all of us, but just in general forensics, because that delays a number of our cases. And what do you suggest? I mean, have you had this experience practicing as a lawyer? And what do you think we can do about it to improve that situation so that when matters get to court, and forensics is what is holding us back, that we, that department deals expeditiously with the forensic aspects so that it can help litigation and judges?
Yes, well, I imagine, Commissioner, that more fundamentally, perhaps it's a broader issue of how the police, in particular, within the criminal justice system, get to do their work. What resources do they have? Because certainly genetic material can't be the complete answer to whatever the issue is that is being examined. So the concerns, seems to me, ought to be much broader than just what could be done with genetic material.
Thank you. And I see you've written a lot about law and technology. Do you think, from your experience, that we are up to speed with technological advancements for IR and things like that in our court systems?
I don't believe that we are as a country, and perhaps I could give an example. 20 years ago, I was looking at my papers. 20 years ago, I proposed an LLM course to one of the local universities. I proposed an LLM course on law and biotechnology, which was intended to deal with the interplay between developments in the law and biotechnology. And the university did accept my proposal as a course, but it wasn't taken up. The subject was thought very esoteric.
Thank you, Deputy Chief Justice. Thank you, Advocate Mooki.
Could I follow up on these points by Commissioner Singh? With your permission, DCJ. Mr. Mooki, I feel that we're doing a disservice to the depth and the breadth of your intellectual contributions and your professional experience. I just want to put a couple of things that appear from your CV. The one is, you, as Commissioner Singh pointed out, is you've contributed scholarly pieces on DNA typing as a forensic tool. You've also contributed on intellectual property. You've also contributed on socioeconomic rights. You've also written about the Truth Commission. You've also written about adjudication. You've also written about patents. It's extraordinary. So I want to ask if it is your intention to continue the scholarship when you become a judge.
Yes, very much so. I'd like to think that I've always had broad interest, and I believe that I'm a better lawyer precisely because of my other interests.
Now, just to close this agency point, I mean, it's funny, me asking you about agency, bearing in mind the fact that you are in the agent court every 2 weeks. The Rule 612 issue, I mean, you clearly are familiar with the two requirements in Rule 612, that an applicant must satisfy the court. They must set forth, I think that's the text, set forth the circumstances that render the matter urgent. And then the second one, and also explain why they cannot obtain substantial relief in due course. I mean, but your point is there's no reason to ritualistically repeat them. Any practitioner knows instinctively what they are.
That's how I understood. Thank you.
Commissioner Nyembi.
Thank you, DCJ. Afternoon, Advocate.
Good afternoon, Commissioner.
My question is about access to justice. The majority of poor South Africans has got still a serious challenge when it comes to access to justice. So in your view, what do you think are the impediments when it comes to access to justice for the poor majority South Africans, especially in rural areas?
Money, the nature of the courts in terms of how they operate, how one gets to get their course through the courts, the process that is involved, and perhaps with reference to the proximity of the courts. For example, with the labor court, when there is an issue in Munsiwa, a labor issue, that person will have to come to Bramfontein, and that person most likely would have been dismissed, and perhaps unjustly so, doesn't have the means that the employer has. But before this person can get recourse, they have to enter the doors of courts through all the instruments that inform how one gets to have their causes heard. Now, with this example, of course, to my mind, I don't see why the local magistrates court in Mafikeng can't be an extension of the labor court. So then the person will not have to travel without funds from Mafikeng to Braamfontein. Those are some of the structural aspects and issues of money to do with access. And those without means suffer the most.
My last question, your worst experience as an acting judge that made you to realize that even after that worst experience, indeed you are ready for the bench?
I must confess I haven't had one. And that's not me avoiding the question. That has been my experience.
Thanks, Advocate. Thank you, DCJ.
Commissioner Club? Oh, I thought you raised your hand earlier.
No, I did not have my hand up, DCJ. Thank you.
Sorry. Commissioner Muiman?
Thank you, DCJ. Good day, Advocate Mooki.
Good afternoon, Commissioner.
Thank you. I'm just building on the first question raised by Commissioner Nyambi on access to justice. The importance of language as part and parcel of the development, because development is communicated through language, and therefore language is also critical to the profession, to the bench. I see that on page 24 of the paginated bundle, paragraph C, you make reference to the pleading that you made in Setswana, and also that you conducted a trial in labor court in Setswana, and you didn't raise it as part and parcel of the, you didn't raise language as part and parcel of the impediment to access to language. Can you reflect on that?
Yes, it was in the back of my mind. Quite rightly, Commissioner, I have never accepted and I've never understood why the English language is given the privilege that it has in public life and in public institutions, given the country that we are. To my mind, especially when it comes to the courts, technically, there is no reason why there can't be a multiplicity of languages being used at the same time with simultaneous translations. It happens in other parts of the world. For example, the European Parliament has got 24 official languages. So when that parliament sits, a member of that parliament can use any one of the 24 languages, and other parliamentarians are able to follow right away. The technology is there. Now, of course, to my mind, it does have a bearing on whether justice has been meted or it's been carried out. There are instances where I was in a matter, medical negligence matter, and the interpreter interpreted certain aspects which wasn't what the witness was saying. And the presiding judge wasn't alive to what was said. And I had to indicate to the court that what was being interpreted to the court isn't what the witness said. Now, of course, this was a civil matter. In the criminal courts, the risk is so much greater that a person could lose their liberties on account of interpretation. There are also time constraints. If there was simultaneous interpretations in the criminal courts, matters will run very quickly, and that will facilitate the rendering of justice. The accused would not have to spend a very long time for their matters being heard, and there have been instances where matters did not proceed because there was no interpreter. So language is important, and it can have a real effect on whether or not justice was rendered.
Thank you, Advocate Mooki. I must confess that on this one, you are on the same par with the DCJ. Thank you, DCJ.
Any questions from the colleagues on the virtual platform? I'll take your silence as consent then. All right. Mr. Mooki, we have reached the end of your interview, sir. Thank you very much for applying for this position, and I wish you all the best. You're excused.
I'm indebted to the commissioners. Thank you.